All right, let's jump right in. We're going to tackle a concept today that is, well, it's powerful and honestly, a little unsettling. It's called the Doctrine of Insignificant Presence, and it might just be the key to unlocking a major puzzle in the world of law.
So here's the big question, right? All over the world, you see these new laws and big court rulings that are supposed to protect indigenous rights and fix the mistakes of the past. But then, nothing really changes on the ground. It's like there's this invisible wall blocking justice, even when the new laws are in place. What is going on?
Well, the answer, according to the research we're looking at today, is fascinating and, yeah, a little bit spooky. The problem isn't always the new laws you can see and read. It's the old ones, the ones that are supposed to be dead and gone. It's their ghosts, and they are still haunting the system.
So, let's talk about these ghosts of colonial law. We need to put a name to this unseen force. We're really just talking about the echoes, the remnants of old colonial ways of thinking that just refuse to fade away, even after the laws themselves are off the books.
And there's a technical term for this: a legal survival. The best way to think about it is like an echo of a legal idea we thought we got rid of, but it's still bouncing around the halls of justice, whispering in the ears of judges and lawyers, and totally shaping how they see things today.
And this quote, this really nails it. These repealed laws, they're not just history. They are semiotically active. That's a fancy way of saying they are ghosts in the machine, still pulling the levers, guiding decisions from beyond the grave. This is that hidden force we have to get our heads around.
Okay, so you're probably wondering, how does a ghost pull the levers of the law? Well, it all comes down to how law reads science.
Here's the key thing to get. Law isn't just a big book of rules. It's a language. And just like any language, it reads signs to figure out what things mean. A sign could be anything: a written document, a specific courtroom ritual, a past decision. All of these things are read by the legal system to create meaning.
And this is where things get really interesting, because you have two totally different sets of signs. State law is fluent in things like written statutes, property deeds, court precedents. That's its language. But indigenous law speaks a different language, right? It uses signs like oral stories, ceremonial practices, and deep knowledge of the land. These aren't just cultural artifacts, they are the law.
So the problem becomes, what happens when one system is completely illiterate in the other's language? The state legal system looks at these incredibly rich indigenous legal signs, a story, a ceremony, a way of using the land, and it just doesn't see law. It sees culture, folklore, or worse, just background noise. It literally can't read the meaning.
Okay, to really see this in action, we're going to look at 3 different countries. We're going to see how Australia, Canada, and Norway have each tried to deal with their own legal ghosts.
And what's wild is that they've all taken completely different roads. You've got Australia, which tried to make a clean, revolutionary break. Then there's Canada, which has been on this super slow, evolutionary path. And then you have Norway. And, well, Norway's story is a pretty shocking U-turn.
So let's start down under, in Australia. For ages, their whole legal system was built on this idea of Terra Nullius, nobody's land, total legal fiction. Then boom, 1992, the huge Mabo decision comes down and says, nope, that's wrong. Everyone thought the ghost was exorcised, but it wasn't. It just shape-shifted. It came back in disputes over water, this time as Aqua Nullius, nobody's water. See? Same ghost, different costume.
Now, Canada's story is more of a slow burn. It wasn't one big moment. It was decades of court battles, inch by painful inch. First, the courts just admitted Aboriginal title was a real thing. Then, years later, they started to accept oral histories as actual evidence. And eventually, they even recognized that how people used the land for centuries could prove ownership. The system was learning to read, but it was like a really, really slow student.
But there's a huge catch here. The research calls it connotative stripping. It's a bit of a mouthful, but the idea is simple. The courts started saying, okay, we'll accept your oral traditions as evidence, like clues to prove a fact, but they wouldn't accept them as law itself. So they took the information, but stripped away all the legal authority. A huge difference.
And that brings us to Norway. And this story is a tough one. For a minute, it looked really good. In 2005, they passed this new Finnmark Act for the Sami people, and it seemed like a new day. But then the Supreme Court started walking it all back, case by case. First, they said basic government paperwork was a sign of state ownership. And then, and this is a big one, they ruled that centuries of intense Sami use of the land was, legally speaking, Insignificant. It all came to a head in 2024 with this absolutely devastating decision in the Karasjok case.
All right, let's zoom in on what happened in Norway, because it is a perfect modern-day example of how these legal ghosts get their work done. This quote from the court, it says it all. Just look at the logic they're using. They're saying, okay, sign number 1, the government has been acting like it owns the land for a long time. Sign number 2, the Sami people didn't really protest in a way we consider a significant protest. So the court reads those 2 signs and concludes, therefore, the state owns the land. It's an incredible move. They're reading government action as ownership, and they're reading Sami silence as consent. It completely ignores the massive power difference and the fact they're speaking 2 different legal languages.
And this is where we get the title of our explainer. This is the doctrine of insignificant presence. It's so subtle but so destructive. It's a way of thinking that doesn't even have to deny that indigenous people exist on the land. It just says that their existence, their presence, their history, their connection to that land has 0 legal meaning, 0 legal weight.
And you have to see how different this is. This is the new face of colonial law. It's not the old blunt hammer of Terra Nullius that just said, nobody's here. This is a surgeon's scalpel. It says, oh yeah, we see you, we know you're here, we acknowledge your presence, but then it adds, and in the language of our law, your presence just doesn't matter. It doesn't count for anything.
Which leaves us with a really fundamental question, doesn't it? What all this shows is that true legal reform isn't just about writing new rules. It's about learning to read a new language. And if law really is a language, then the ultimate question of justice is really a question of power. Who gets to decide which words have meaning? Who gets to be the editor? And whose entire language gets dismissed as just silence?